I'm Major Lindsay Olson. I'm the General Counsel for the Minnesota National Guard. And today we're going to talk about military family law. We're going to do an overview of some of the basics that you might encounter if you're facing a military family law situation, which includes divorce, child custody, child support, or child visitation. This presentation will provide an overview of the few main legal issues to be aware of and things you can ask your attorney when working with them. It's not intended to provide legal advice for your specific situation. Some of the main areas that we'll look at today include the Uniformed Services Former Spouses Protection Act. That's kind of a mouthful, but it's one of the main laws that discusses military pension division, an important part of most military divorce cases. Handling stays under the Service Member Civil Relief Act. The Service Member Civil Relief Act may be a law that you've heard of before if you're at all familiar with laws affecting service members. And we'll look at military retired pay and some types of disability pay that will also be impacted. If you're dividing a military pension, you want to make sure that you'll have a military pension division order, and we'll talk about that just a little bit. We'll also talk about different types of spousal benefits. This is an area that people get very confused about. And we'll talk about custody for children and children's visitation. The first thing we're going to talk about is the Uniform Former Spouses Protection Act. This is a federal law that doesn't tell a state how to divide military pension. It simply says that the military pension is a divisible asset. Remember, in a divorce case, everything is going to be dictated by your state law. So whatever state you're in for your divorce, that's going to be the state law that's going to apply to that case. What the Uniform Former Spouses Protection Act does is provide a basis for what's called jurisdiction, which is what is a term that gives the court the ability to take a case. And this jurisdiction has to be specific, and it has to be stated in your divorce decree. And that's very important because otherwise the military pension division might not be valid. So it's very important that you discuss with your practitioner and know that your attorney understands the Uniform Former Spouses Protection Act so that your rights, whether you're a spouse or a military member, are going to be protected in this action. Valid jurisdiction, that is the court's ability to, again, hear your case and make a decision on it, can be based on domicile, that's where you live, the state in which you're a resident, consent, or residence. And domicile and residence are different, and that's something you should talk to your attorney about based on your situation. The next thing we'll talk about are stays. Stays of court cases under the Service Member Civil Relief Act. The Service Member Civil Relief Act is a general statute of a federal law that applies to service members for many types of situations, but it also applies in divorce and custody cases. Now, a stay under this law will stay your court case, and it will allow you to have a period of time where you don't have to do anything on your case if that's something that's of benefit to the service member. The service member is the one that has the right or the ability to request the stay. If they request an initial stay for 90 days, the court must grant that stay. Additional stays for additional time are also allowed, but they're at the discretion of the court. That means the court can decide whether to grant that additional stay. Another party to the case can't request a stay. It's only the service member or the court that can determine the stay. The stay does have requirements, though. So in order to request the stay, the service member will have to show that they are unavailable, actually physically unavailable to appear in court due to military duty. Normally this will require them to be in a place where they can't come back physically or appear by VTC to be available to do their case. Now, what you should be prepared to show is a copy of military orders. You will need, by law, a statement from your commander saying that you are unavailable due to military duty and that you are not granted any leave from your current location. Those things will have to be included in the stay request to make it valid under the law. But don't think that you always need to ask for a stay. You may want to proceed with whatever the proceeding is, whether it's a divorce or a custody or child support. And specifically with child support, it's an important factor to consider. You're probably not going to have the ability to stay a child support action. And you probably don't want to do that because if you have the requirement by law to pay child support, you're going to have that requirement whether or not you're on a military duty in another place or whether or not you're there in the state. Because military duty, even a deployment, would not get you out of any type of child support requirement. In fact, the military can put on additional child support requirements by regulation if you don't have a child support order through the court. Now, if that is your situation, if you don't have a current child support order, you will want to see your base or post legal assistance office and talk to them about what your child support or family support requirements are under the appropriate regulation for your military service. If you're a military service member or a spouse, you'll want to understand what those are.